little sweetheart.
They can't do nothing because I tap dance.
This is WVCR 88.3 FM, The Saint. You are listening to Calling Out Controversy, featuring hosts Andrew Hecht and Justin Kenyon. And welcome to Calling Out Controversy. You know who it is. Same time, same place, every week. Summer rights. Let's do it. Okay, so current events today, a little different. I want to focus on two articles that I read. One is Quora, so it's just an open public forum, but it shows up in the Quora Digest that I ended up subscribing to because I had a project in school, and I don't know. I get emails from Quora now. That's how I found it. And then the other one is from the Seattle Times. I want to say it's called the Seattle Times. Yeah, the Seattle Times. Look at that. So let's start with Seattle Times, because Seattle Times put out an article, I think today. Yep, at around 6 a.m, and it was. How do you deal with your political outrage at work? But that's not the title they used. They used when the world is a dumpster fire, but you still have bills to pay. Apparently, the world's a dumpster fire. So obviously they take the everybody should do this stance. If you're a sentient being with access to the daily news cycle, chances are you vacillate between outrage and despair multiple times a week. That is what the Seattle Times assumes all sentient beings feel when they listen to the news. Besides being emotionally exhausting, this roller coaster is hardly conducive to getting your work done. Embracing apathy can be tempting, especially when staying informed affects your on-the-job productivity. Okay, pause. Listen, if you think that you can't handle staying informed, you're failing as an American. I just want you to know that's how I feel. Because the whole point about civil discourse and the point we try to raise on this show is that you should be informed at all times, and you should do so with a cadence in a manner that does not embrace the fact that something upsets you to the point of outrage. You should do it with a cadence and a manner and a demeanor of, I disagree with something, so allow me to contribute. You know, it's something that you should do just so that way you know where you stand in the world, because that's how you know what's going on in your life. So there's a few points that they raise that are actually smart. But it's the fact that, A, they assume the whole world is going to hell in a handbasket, which is such a pleasant assumption of current events. I get the point you're making, but let's break down what you're suggesting. The first thing is to schedule your outrage. That's how they phrase it. Schedule your outrage. Pick a time to be mad about something. That's so silly. Why are you being mad? Why are you getting mad? Why are you getting mad? You don't control it, right? Unless you go out and vote and you get active, right? But you know, apparently that also makes you mad. So how about you just stop letting things get you angry? Well, just stop getting mad. Stop it. Just calm down. Okay? The world's not ending. Things bad happen all the time. And you need to just live with that. You need to be an adult and accept the fact that if you really want something to change, you should get involved. All right? Which is the second point they come to, which is commit to at least one ongoing political act. I agree with that, actually. I don't agree with the ones that they suggested, but I think that's true. You should commit yourself to one political act. You should call your Congress representative or Senate representative. That's fair, but not every morning. A weekly donation to your political issue of choice or a monthly act of civil disobedience. Okay, why is the Seattle Times taking the stance that you have to be civilly disobedient if you don't agree with something? You can play the game like many lobbyists do. You know, we did an episode on lobbyists. He plays the game. Can we agree that maybe lobbying for something or getting involved is a better option than being civilly disobedient? You're enticing people to stage rallies and protests. That's what you're doing. I'm saying this for everybody. Just, dude, get involved in a proper way. Obviously, if you want to call your congressman, again, great idea. Make a weekly donation to a political issue of your choice. Sure, pledge your money. That's a great idea. If you want to go out and protest, do so. Build it into your calendar was a funny thing, because that's not exactly civilly disobedient, is it? You're calling out of work to go be disobedient to the government. Just, I don't know. I mean, it's just a silly what do you call it? Contradiction in principle. And there's you still can be concerned about society without thinking too deeply on it or working to improve it every hour of the workday. So while you're busy with your job, don't focus on society, and then when you're off the clock, focus on society. It's not, again, there's good ideas and bad ideas in here. Commit to broadening your socially conscious horizons at least once a quarter, which is step out of your comfort zone. That's the next one. It's always the comfort zone. You always got to step out of the comfort zone. Read up on a distressing issue you keep meaning to learn more about. So these are all coming straight from the same article. I agree with that. I think that's a good idea. Organize a food, clothing, or fund drive. It's a good idea. That works. Among workplace colleagues, though, maybe not the best idea, because you're talking about not doing this at work, and then you're telling them to do it at work. Don't do that. Don't do that. I don't like that idea. And this is another option I really dislike. Speak out against your employer's support of an unjust cause or political candidate. Let's get one thing straight. He's your employer. You work for him. You make money for him, but he gives you the money. He's paying you to do that. There is a workplace relationship there. You cannot, under any circumstances, think it's okay to just lambast your employer because you don't agree with something that they're doing. Unless you work for a major corporation, chances are you're immediately fired, because small businesses don't play that game. But on top of that, this is an article about how to not do it at work, how to not have these problems at work. And now you're telling them 3 steps in to speak out against your employer's support of an unjust cause. Hey, who says it's unjust? What cause are we talking about? That's very general. Unjust cause is opinionated. So basically, it's telling you if you have a different opinion than your employer, you should let them know. Bad idea. I'll tell you from experience, bad idea. Okay, last tip. Take time to compose yourself as needed. If you're so distraught over the suffering of other humans that you can't keep your collective gear together at the workplace every day, go to a therapist, please, because other workers don't care. They don't care about how you're affected. They're here to make money. They're here to do a job. Unless they're your friends, they don't care. I can tell you this right now. The examples they give are natural disaster, mass shooting, or unfeeling act of a political leader. Unless your family, God forbid, is involved in the first 2 of those 3 things, empathy is fine. There is no need for you to get emotional about it. It happens. Natural disasters are called natural disasters for a reason. And unfortunately, in this country, school shootings are I wouldn't say common occurrence, because it's not common, but it happens far more than anywhere else. And it's very shameful and sad that we live in a society like that. But again, unless, God forbid, that your family is involved in something like that, why are you to the point of breaking down at work? And then much more briefly, Quora. Obviously, there is a gentleman out on Quora that had a question that he answered himself, because why don't you answer your own questions in real life? I'm not going to say his name because I'm not going to put him on blast like that. I don't know this person, but the question was, is fiscal conservatism fiscally irresponsible? Okay. He seems to think it is. His justification is that every time a Democrat has inherited a Republican economy, it has been awful, and that is justifiable evidence that supply side economics doesn't work. Okay, I'm not advocating for supply side economics. I just want to point this out. Presidential decision making on economics and the economic direction of the country has little to no impact unless in emergencies and crises. There is I want to say the website is called 538, gives a really good answer to this question. And the answer is that it takes decades to show economic results for policymaking, for fiscal policy. For monetary policy, it's immediate because the Fed is controlling everything. But for the by and large, presidents really don't have that great of an effect on the economy. So it doesn't matter if it's a Republican or a Democrat. They point out the same financial crises that this person on Quora pointed out. The links are below on YouTube. You should look at the two, and I think you'll see my point, which is that, yeah, man, you can think that Republicans are horrible at the economy, and you can give your justification for that by listing a few things that have nothing to do with each other, but long story short, it really doesn't matter. It really, really doesn't matter that soon. It's a long-run issue. Just like the housing market, which you incorrectly stated was a deregulation problem. It was a corruption problem. It wasn't deregulation. They had regulating agencies. That's what S&P is. That's what Moody's is. They're ratings agencies. They're supposed to regulate the quality of tranche and mortgage loans. And they were being bought out criminally. And they didn't get prosecuted, which is the bigger problem. But the fact is that you had a fraudulent system. You had a corrupt system. It has nothing to do with deregulation. It has to do with the fact that people were making criminal acts which were already illegal. The underfunding of the SEC, you can argue, sure, but it's been going on for 3-4 presidents. It's not like it was new to Bush or Obama. They had nothing. They had no idea. Nobody had any idea. It took geniuses to figure out that it was going to collapse. But it has nothing to do with the president. That's silly. Anyways, we'll be right back. Because we have a very nice interview on the Sixth Amendment with Bob Farley. And that is what we're going to cover next on The Saint.
Hello, welcome back to Calling Out Controversy. I'm Justin Kenyon. With me, as always, is...
Yeah, what's up? It's Andrew.
And with us today is Bob Farley.
Thank you for having us.
Yeah, well, why don't you start off by telling us a little bit about yourself?
Go.
Well, I'm a senior counsel to the New York State Senate Minority Leader. I've been a legislative counsel in Albany for nearly 30 years. I'm also former Deputy Attorney General for the state. I served in that role in the mid-90s. Before that, I was a counsel to the Assembly Minority, and I served as a majority counsel in the Senate for most of my career. I am also a former elected official. I served as a Schenectady County legislator, including chairman of the board for nearly 20 years. And also I am a professor of law at the State University of New York at Albany. I teach both property law as well as the law of business organizations, which is corporations, and as well as partnerships and LLCs and things of that nature.
Yeah. Awesome, man. Well, glad to have you here.
We're delighted to be here.
I appreciate that. You're obviously a good family friend, uncle to Justin here.
I love the whole Kenyon clan, and Justin is the best of them.
That's perfect.
Thank you.
So we're here to talk about due process, right? The Sixth Amendment. I understand that you're very well versed in the history of the Sixth Amendment.
I'm familiar with it. You know, if you look at the concept of due process, came out of John Jay, who wrote our state constitution back in 1777. And it's coming up on its 250th anniversary in a few years. But John Jay was an incredible lawyer. And many of our founders were some of the best lawyers in the history of the universe. And John Jay was at the top of that class. He wrote the state constitution 10 years before the federal Constitution came into existence, because the federal Constitution was done in Philadelphia in 1787, which is 10 years later. Jay also distinguished himself as being one of the authors of the Federalist Papers as well. He argued what the importance was of the federal Constitution so it could be ratified. But much of his work, including the Sixth Amendment that we're going to be talking about today, came out of his work for the state constitution. And if you look at Article 1, Section 6 of the state constitution, you see a lot of the same elements that ended up in the Sixth Amendment. And it's tied in together. It's a transition there. And some say that it was actually improved. It was definitely shortened by the Sixth Amendment of the federal Constitution. But there are some of the most important concepts to our liberty and our freedom contained within that amendment. The independent judiciary that we have in our country, people just generally don't appreciate it because they've lived with it and they've gotten used to it. But it really is the envy of the world. And one of the reasons for that is the fact that it really keeps us free. The elections of legislators and executives, whether they be the President of the United States or a governor or Congress or a state legislature, that is very helpful, and they're responsive to the people by means of an election. But our judiciary is what really keeps us free, because if you have a problem with your rights, where do you go? You go through a court.
Right.
And whether that be civilly or criminally, they protect your rights more than any of the three branches. And the lawyers of our founding, whether it be John Jay or Alexander Hamilton or James Madison, they understood that. And, you look at some of the real giants who created our system of government, many of them were lawyers, and they understood the value of the court system. And, when we produced the Constitution and had it ratified, it did not have the amendments to the Constitution that we call the Bill of Rights in it.
Yeah.
It was deemed by, matter of fact, Madison, who wrote the primary part of the Constitution, didn't view it as necessary because he viewed that your individual civil rights were protected by the states, not by the federal government.
Really?
Because the federal government was a government of limited jurisdiction, and most of your civil rights are infringed upon by the individual states because their state constitutions gave them much more power. So he didn't view that this new federal constitution that set up this federal government needed that. But when it came about for ratification, and there's a wonderful book that came out a few years ago called Ratification, which goes through each one of the states, how it was ratified. And incidentally, New York was one of the last states to ratify the Constitution. It actually ratified it after it became law, because it had to have 9 states ratify it under its provisions to become law. We were the 10th. And but when New York State ratified it, you had several other states before then who wanted to put in a caveat that we needed a Bill of Rights. And there was no provision in the Constitution, in the federal Constitution, for any changes to it. As far as, they couldn't say we want a Bill of Rights, or we wanted this condition, or we wanted this amendment. Well, what happened was, because of the fact that it did get ratified in several, including Massachusetts and Pennsylvania and some of the major states that helped to create our nation, said after when they ratified it that, yeah, we're ratifying it, but we want Congress to do a Bill of Rights. So the reason they call it the Bill of Rights, incidentally, was because James Madison, who ran for the House of Representatives, because of the fact, and he came from Virginia, so there were a lot of big players in our foundational government that came from Virginia, including the first president of the United States, was George Washington. But when Madison came into government, he ran for the House of Representatives because he said that was the body that was directly elected by the people. Because back then, senators were appointed by state legislators.
Yeah.
They were not directly elected. So, and the president got elected through the Electoral College. And as a result, he said the only people being directly elected was the House of Representatives, so I wanted to do it. And in the very first Congress, in the very first session, he said, I got to keep my word to everyone, because he went out and really put himself out there with the Federalist Papers. He said, I want to keep my word by having the Bill of Rights. And he wrote in a bill into the United States House of Representatives that they passed and sent out to amend the Constitution with 12 individual provisions that would become the Bill of Rights. The states ratified 10 of them, and that's what we know as the Bill of Rights. And the reason why it had that moniker, because it was actually a bill in the very first Congress.
Yeah.
And one of the principal rights that we have are embodied in the Sixth Amendment. And when we were discussing this previously, Justin asked, which is more important, prosecutorial misconduct or the ability to have a defense and your access to the court? I would say they're flip sides of the same coin. I think they're equally important. You cannot have rogue prosecutors. That is against your freedom, and that's what we have in countries that you have no civil rights. Because, from the date of the Magna Carta, we have to have restraints. A prosecution is an executive authority.
Yeah.
And a prosecution cannot be rogue. And throughout the course of our constitutions in both the states as well as the federal government, we've put serious restrictions on prosecutorial authority. Matter of fact, in most states, including especially in New York, that's why prosecutors are elected. Your district attorneys are elected. It's just another check. If you have someone who is a rogue prosecutor, they will be defeated at the polls because it becomes the news of the day. We just passed, which is kind of interesting, just last session, for the first time, a commission that's going to look at prosecutorial misconduct, because it is a very serious issue. You cannot have a rogue prosecutor out there that is not abiding by people's civil rights. Prosecutors do not have the charge to get convictions. They have the charge, and they take an oath of office to do justice.
Well, while you're on that, though, don't you think that there is pressure in terms of a career and its longevity for a prosecutor to get convictions? Like, prosecutors are, by and large, deemed successful by how many convictions they have.
I think prosecutors are successful by bringing down crime. And prosecutors in our country bring their cases in the name of the people. When you are in even England, which is a very free society, not as free as ours, when you get charged with a crime in England, the title of the case is Regina versus Jones. Regina being the king or the queen in that case, because we have a queen now, Queen Elizabeth. In the United States, if they bring in action, it's the people versus Jones. The people are sovereign under our system of government. It's not the president. It's not the government. It's the people who are sovereign. That's why the Constitution was ratified by the people, because they're the ones in control. And that constraint is directed on prosecutors. That's why prosecutions are brought in the name of the people. And those people are represented when they go after people who have committed criminal acts to be able to hold them accountable to the people. Now, can a prosecutor go beyond the bounds of the law? They're given an awful lot of power. And when they violate the civil rights of individuals, they should be held accountable, whether it be at the ballot or whether it be under the rules of professional conduct, because all of us as lawyers also have to follow rules of professional conduct. It's not just what the individual person would have to follow. It's also what lawyers have to follow.
So in a scenario regarding professionalism as a prosecutor, do you think that it's appropriate for a prosecutor to hold on to evidence that is influential or important for someone's defense until the last possible second and then just unload it onto the defense attorney?
Exculpatory evidence
Yes.
needs to be put forward immediately because of the fact that, now that's not all evidence, but exculpatory evidence needs to be put forth immediately, because what, again, is that charge of the prosecutor? It's not to get a win. It's not to get a conviction. It's to do justice. Now, if you have a person who is charged with an offense and you have evidence that's not exculpatory, you can follow the directives of the discovery guidelines within the criminal procedure law.
But who defines what is exculpatory? Like aside from obvious exculpatory evidence, what is the criteria that defines exculpatory? Because if it's at the judgment of the prosecutor, can't they?
Well, the problem is
choose not to define
none of
it
this
that
is
way?
done in a vacuum. Okay,
Right.
because of the defense is entitled to all of the evidence that the prosecutor has.
Yes.
It's unlike a civil case where some of the evidence you may not want to put forward. So you as a defense in a civil litigation, you may not get all the evidence that's out there because sometimes the plaintiff does not want to present it. And if they never present it, you never get it. Okay.
Right.
But in a criminal prosecution, you're entitled to everything. The question is when. And if you're eventually going to get it, and nothing happens in a vacuum. So if a prosecutor is holding back exculpatory evidence, that is going to be reviewed after the conviction and is a justifiable reason to overturn the conviction, as well as a justifiable reason to sanction that prosecutor. Because when evidence is exculpatory, even if it's a close call, okay, it's going to come down against the prosecutor. And it should, because the whole purpose of that is to do justice. And discovery is a means by which the defendant gets the information that is out there in the case. It's not something that isn't, a state secret, say.
Right.
It's information that you have that you're going to use to try and convict that person. But the whole purpose of a prosecutor is to go out and try and protect society by holding people who commit criminal activity as sanctioned or as outlined by the state legislature, because crimes are principally state. But they are trying to say, if you have broken the law, you're going to be held accountable. The real problem with prosecutors that has really gone on has not been at the state level, because of the fact, and there are exceptions. You've had a rather significant case a number of years ago with the Duke lacrosse team, where a prosecutor for political purposes indicted all of them on rape, and it turned out some of them weren't even in the vicinity at the time. All the convictions were overturned.
Yeah.
And it was a huge embarrassment. And that prosecutor was removed, and he should have been. It was real, but that's one of the reasons we have elections. But at the end of the day, you have not had across the United States the real abuse on prosecutions on the state level, where you've really seen an overzealousness, and I think a violation of rights, has been on the federal level. And it's interesting to note that those federal prosecutors, the U.S. attorneys, are not elected. They're appointed. And they have tended to abuse their authority, and they have a lot of authority because when you get prosecuted by the United States government, you have all the resources of that United States government coming after you. And there was a very sad bill, I think, that was passed by the state of New York this year that allowed for persons, we had traditionally in New York State prohibited a federal action against or a state action when you had a federal action against you. So if you were prosecuted by the federal government for a series of events, we had a prohibition based on the concept of double jeopardy that the state could not then come in and prosecute you because you've already had to deal with that one prosecution.
Right.
The state legislature this year passed a law that said, guess what? We're going to abolish that. And so now the state of New York can go after and do that double jeopardy prosecution. There's an old adage in the law that said bad cases make bad law. I mean, the reason why the legislature passed it was because they wanted to go off and prosecute persons in the Trump administration. And there's such angst and hatred of the Trump administration amongst certain sectors that they passed that. Well, that's not a reason to abolish 240 years of restricted jurisprudence.
Right.
Double jeopardy is in place for a reason, and you should not have to face multiple trials. Because what ends up happening is, even if you're innocent, you can't defend yourself because you're out of money and no one is going to support you anymore. It's a very challenging thing.
I think we actually covered this in current events when it came up.
Yeah.
Paul Manafort, right? Wasn't
Yeah,
that
when he moved to Rikers Island. Then
Right.
off of the major points you've made, it seems essentially that it becomes basically awry when it becomes political.
Yes. I was a prosecutor in the Attorney General's office. I was Deputy Attorney General for the state. And I was very proud of my boss, who was the Attorney General, who always said that politics and public safety do not mix. And what he was saying is, when you make a decision on prosecution, keep the politics out of it. It is not something that we should involve because it leads to bad decisions. Because one day that might be the person who you want to go get, and tomorrow it's the person you want to save. It is not, the winds of politics should not get involved in these decisions. It's not always easy to see the civil rights of people who may not be good people. But at the end of the day, civil rights protect everybody. And that's the benefit of what we have in the Constitution. Your right to counsel, your right not to self-incriminate, your right to be able to have people who are accusing you confront you with the charges. All of those things are being circumnavigated under federal law a lot, and they really shouldn't be. Part of it is because of the fact that you now have more and more jurisdiction under federal law. It used to be a very limited jurisdiction for federal prosecutors. Now the Congress has gotten much more active, and there's a lot of overlap. Because as we said in the beginning, you used to have a circumstance where the overwhelming plurality of crimes were prosecuted on the state level. Now it's a by type of thing where you have both jurisdictions going after people. And you know what? The Constitution should stand up for everybody.
Now, you've mentioned politics and due process getting entangled in a negative manner.
Yep.
I kind of want to turn the conversation just a little bit to talk about the concept of crucifixion by public opinion, which is where the media or news outlets, whoever they are, kind of take a side with a controversial case, and public opinion will kind of convict a person before he's had his day in court. The most recent example, which I can think of, would be the confirmation of Supreme Court Justice Brett Kavanaugh, where there was no criminal charges filed against him. And yet we saw an outrage in the public, whether right or wrong, that's not what I want to focus on, but we saw an outrage in the public about what may or may not have happened in his past without any substantial evidence, without a proper trial, without due process being given to him to be found innocent of these allegations. Instead, it was during a confirmation hearing where conjecture was thrown about, and they just wanted to know whether or not he's fit for the bench. I want to know your opinion and your take on how we treat people at certain points in time, and we come up with reasons for them not to do something or not to be hired somewhere or not to be elected without giving them a day in court. Because he's not the first person to face a criminal allegation but not get a criminal trial. You know what I'm saying? Like, I don't know if I'm saying it correctly.
No, I understand where you're going, but there's and as somebody who has run for office, believe me, politics can be a very difficult pursuit. And someone who is looking into becoming a Supreme Court justice in our very polarized society should definitely expect some very thorough vetting. That being said, I think that case was a situation of character assassination, and I don't think there were an awful lot of people there who were bringing up allegations which were not only not substantiated, but have been proven since to have been just fabricated. Is that wrong? Yes, but it's morally wrong. And the result was, I think, that the United States Senate took a look at that and said, guess what? There's not the evidence there. And they made that decision based on whether or not he had the character for confirmation. They found that he did, and he was confirmed. I think, on a moral basis, that this character assassination, and you can it's on both sides. It's very detrimental. I can see. I've never attacked my political opponent, and I ran in a district which was not in my political party. Matter of fact, I was the only person of my political party to win that district when I ran. But I can tell you that I never attack my opponent. I don't like that. It's not who I am as a person or as a belief in politics. But that being said, it's out there. And believe me, it has gotten vicious. I think it's vicious to a point where it's detrimental to our society. But when you're talking about that kind of thing in a criminal context, it adds a whole new issue. Obviously, there's ways that there's tools that they give judges to sequester juries and to be able to try and limit that outside influence. But it's really tough because you can poison a jury pool on that, what's happening. We're supposed to get a trial of our peers, but if the peers all in a certain area have been poisoned because of unfair media, that's really tough. And how do you control that? I think the worst part of all of this, to be honest with you, is the violation of what we call statute of limitations. And statute of limitations seems by some media accounts to be unfair, because why can somebody just wait out the clock and get away with something? But the problem with doing away with statute of limitations, and we've done away with it in certain areas, is a real problem. That came up with the Kavanaugh confirmation, because these were things where the statute of limitations ran a long time ago on these activities, even if they were the case, which it didn't seem to be. But the problem with statute of limitations is they're there for a reason. Memories fade, documents disappear, people, die. So if we want to have an incentive, particularly in the criminal context, to be able to have people have fresh memories, good evidence, and good documents. And if they don't bring the case within that sufficient time, it shouldn't be brought because you have much more of an opportunity for a miscarriage of justice, one way or the other, and it's not good. One of the back in the early 1980s, you had Rudy Giuliani, who was United States Attorney for the Southern District of New York, and he made it his mission to try and really take on the mafia in New York City. And that's where he made his claim to fame, was going after all of the crime families in New York City. And when Rudy Giuliani did that, he made sure that his prosecutions were brought on a timely basis and that they were brought against the people who deserved it. Now, one of the ways that some of these crime families tried to get out of their prosecutions was murder witnesses or intimidate that. John Gotti bribed jury pools several times and got off. He was known as the Teflon Don for a long time before they eventually got him because he'd actually intimidate the jury pool. And the same kind of thing can happen with statute of limitations. If you try and prosecute somebody after someone has all the witnesses gone, that's no different than what the crime families were doing. It's not a good way to go.
Right. And that's there's that aspect of it. There was also the aspect that the allegation was made of him as a minor. So because of the statute of limitations, like you said, he would have been charged as a adolescent possibly had that actually happened in a timely fashion.
Well, you could also see it in the testimony that was alleged against him. There were all kinds of holes in that testimony because it took so long.
Right.
And, I can tell you that we want prosecutions to go forward. We certainly, particularly, some of the acts that were alleged against Judge Kavanaugh were horrific if they were true.
Absolutely.
Those kinds of things should have been prosecuted if indeed they happened.
Right.
And we want people to come forward. We want prosecutors to bring those cases. But just like, it's a balancing test. We don't want that kind of behavior to go scot-free, but you also don't want to destroy people's lives by bringing up allegations that can't be proven. And that's a problem.
Right. And that's what I wanted your opinion on. I thank you. What else? Inadequate defense, right?
Yeah, I was about to ask
Go
you.
for it.
What do you think are pretty much the main causes with inadequate defense? Because when most people think about inadequate defense, they mostly talk about public defenders and how they're underfunded and everything.
Which we brought up 2 weeks ago with Kevin Lewebrand.
Yeah. Would you say that's the main cause, or you say there's other causes with that?
Well, I mean, there's two aspects. When you are a criminal defendant, you're entitled to a defense. But obviously, any defense that you're going to get if you're indigent, if you're a multimillionaire, you're going to be able to hire the finest lawyers. There's really not much of a problem with that.
Yeah, like
but
the Dream Team with O.J. Simpson.
You got it.
That.
Okay.
Yeah.
But with respect to someone who's indigent, who's going to get the public defender, I can tell you public defenders tend to be way overworked. They have enormous caseloads, and they tend to be young lawyers right out of school. And that's not to trash public defenders, because so many of them are very talented people. But experience, like in any type of field, really helps improve your quality. And when you're handling 300 cases and trying to do this as a brand new lawyer, you don't have that body of knowledge to know how to be able to circumnavigate the justice system.
You also don't have the time.
Well, that is probably the biggest issue, because you don't have the time. Now, what has led out to that is the fact that pretty much when you have lower level offenses, they tend to get pled out. So the modern justice system, and I don't necessarily believe this is good, but it is where we are, they plead most of the cases. They do not bring most of their cases to trial. Indeed, in order to bring a case to trial, it's generally got to be a felony, got to be a serious felony, and they have to have so much evidence on them that the person won't plead because the district attorney won't plead it. So most of these get pled. The problem is are all these plea deals justified? What ends up happening is the public defender comes to the client and says, look, I saw everything that the prosecutor has. They really have you nailed. If you take this plea to a reduced charge, you'll end up being in jail a lot shorter period of time. If you turn around and roll the dice and try and get acquitted, you're going to face a lot longer period of time. It's a cost-benefit analysis for the client. And more often than not, the client will take the reduced plea. I pray that people aren't taking plea deals when they weren't guilty. Frequently, it has been found when they have done that one of the reasons they've done it is because they were actually involved in the crime, maybe not the perpetrator, but there's something else involved on it. But I think one of the best civil rights developments in criminal justice that has led to better prosecution has been DNA. I started my legal career before DNA was involved. And, you did things like fingerprints and you did things like, blood types and things like that. DNA has revolutionized prosecutions because when DNA evidence is there, it's very difficult to fabricate that, and it's very difficult to get out from under it. And the DNA evidence has really helped prosecutions. Matter of fact, there's been numerous prosecutions that have been overturned because of DNA evidence. And DNA evidence is really good. It's not perfect, but it's really good and much better than somebody's fingerprints or that somebody's blood type that was on the scene. And I can tell you that many more cases end up getting either pled down substantially or not brought at all because of DNA evidence.
The Innocence Project does a really
Yes.
good work
Yep.
with that, right?
Yep, they're very active in it, and they've overturned an awful lot of death sentences.
Yeah. There's a book called Convicting the Innocent that I had the privilege of reading year and a half, 2 years ago, and a lot of it is centered around prosecutorial misconduct, inadequate defense, DNA evidence being the saving grace for a lot of people on death row.
Yes. It has overturned dozens of convictions. The Innocence Project's been very active on it. And I think equally important, it has persuaded prosecutors not to bring actions because jurors are pretty sophisticated. Believe me, I've tried cases. I was a trial lawyer for 7 years before I went into government. And I can tell you, juries can smell where you're going. And if you have a circumstance where you don't have DNA, that's the first question they're asking in their mind. Where's the DNA evidence? How come you don't have it?
Right.
And prosecutors understand that. Prosecutors don't want to lose in court. They have a 95% conviction rating. They don't have a 95% conviction rating because they're so much more powerful than the defense attorneys. They don't have a 95% conviction rating because there's misconduct out there. They have it because they plead all the bad cases.
Right.
So when they're bringing a case, they know that this is a good case. Or it's a case where the person says, I don't want to plead. I'm not guilty. And those tend to be the cases where you have the 5%.
Right.
Because the person, particularly if they have a good lawyer, And there are good public defenders out there. And there are things like legal aid who can help them. And the best public defenders are the ones who end up trying the cases. Now, the people with the 300 caseload, those are the people who plead them. But the ones who try them tend to be the finest in that shop. And they I will tell you, they can really spin and let their client be helped.
Yeah. So it seems to be it's kind of just basically an effort of giving them less coursework, but giving them more of an effort on it.
Well, I think, one of the things we do have to be fair in resources, because I think you do need to have you touched on something I think that's very important, Justin. We not only need to have prosecutors have resources, because they have huge caseloads too. ADAs can have a caseload of hundreds of cases too. And I think it behooves both sides to have sufficient resources, because if a prosecutor has time to look over the case, he can also look it over and say, it's not just to push this thing ahead, or we have to reduce the charges because there's mitigating circumstances here. And the same thing on the defense side with the public defenders. You have to have enough resources where people will be able to not just say, you're just a number, I don't care, I'm going to plead it. And, that's important. You also have to be able to have good lawyers want to stay in that role, not just go on and become I'm going to go over into civil law and become a trial lawyer and make a lot more money.
Right.
So if you have enough resources, you can pay those individuals enough to stay there for a while. And, they learn their craft and they get better because they said, this is what I did on this case. It didn't work. This is what I did on this case, and it did. And, that really helps. I can tell you as day one as a trial lawyer, I was definitely not as good as when I was after a number of years. It really helps.
So in your experience, do you have a case that best exemplifies due process working perfectly, or double jeopardy being kicked in and then you having to fight it? Or do you have like a case related directly to the Sixth Amendment that you can share with the listeners that you think emphasizes a great piece of it?
Well, I think, the Sixth Amendment is one of our linchpins of freedom. And if you look at, there's a number of cases in the law that have been out there in the history of criminal law. You look at more recent litigation out there. I will tell you, I think that some of the most recent things regarding the prosecutions in governmental officials relating to what has gone on with Robert Mueller and what has gone on with respect to some of the prosecutions out of the Trump campaign. And some of those people have done some really bad things, it appears.
Yeah.
Okay? I have no problem with somebody who commits bank fraud getting convicted of bank fraud.
Right.
But what I have seen here in like today's announcement that they're going to go after one of the people who was the chairman of President Trump's campaign after they already got a federal conviction. That's wrong. Okay? And he should have been convicted on federal grounds. He was convicted as a juror. But you don't want to use the incredible power of government to go and put somebody in double jeopardy. I think that's a real serious problem. But overall, the Sixth Amendment, again, John Jay's one of my heroes in government. He was the first Supreme Court Chief Justice. He's a brilliant legal mind. He came up with, in that Constitutional Convention that was held in White Plains in 1777, in the middle of combat operations of the Revolutionary War. Because in 1777, the entire state of New York was involved in the Revolutionary War. The Battle of Saratoga took place in 1777. They had a battle in Ticonderoga. They had all the battles that happened in the Hudson Valley. There was a major battle outside of West Point. All these things were happening at the time he's writing the Constitution. The British forces would have arrested him and tried him for treason and put him on a tree with a rope around his neck.
Yeah.
That was the time that we were writing our Constitution. And Jay then turns around and pushes the same concepts. He turned around and in that Constitutional Convention in 1777 talks about due process of law for the first time. That had been a new concept. He kind of took it out of some theory that was in English jurisprudence, and Blackstone kind of opined on it a little bit, but it was really first advanced by John Jay. And then he puts it into the Sixth Amendment. And that focus on making sure that our judiciary is a vehicle to keep us free. It's up to judges to make sure that prosecutorial misconduct doesn't happen, because they review the case. Those prosecutions do not happen in a vacuum. They happen before a judge. And that judge has an obligation to make sure that the prosecution is for the purpose of finding justice, not just to railroad somebody. That's why he's in that room or she's in that room, to do that. And this provision of the United States Constitution empowers those judges. It gives them certain rules by which they have to operate. They have to make sure that there is sufficient legal counsel. And if their counsel is so bad, that is grounds to overturn for appeal. Matter of fact, most criminal arguments for overturning an appeal relate to insufficient counsel that they had. That's one of the arguments, it's boilerplate that is always put in. And it's one of the, if you have a counsel who's a year out of law school and they didn't advise you of things they should have, that's grounds to overturn the appeal. And you can turn around and get a new case. They have to make sure that the witnesses confront them. That's very important. You know, throughout history, that was not the case. They could bring charges against you, and the people who brought them, you didn't know who it was.
Right.
And that would you. There's no way you can operate a defense if you don't know who these people are.
That's actually an interesting concept, because here, this is obviously not a court of law, it's a private school. But here we have something called an anonymity clause, which means that you can report and accuse someone of harassment and they never get to find out who you are for what they're saying is your safety. So if someone were to place an accusation against another student saying this person made me feel uncomfortable or said something wrong or did something even, the person accused will never know who brought that accusation against them, as long as it stays within the confines of Siena College.
Accusations should not be used as a weapon.
Well, I believe that. I absolutely believe that. Yeah.
And that's why you have these constitutional provisions, because it should, justice is blind. There's a reason why you have Lady Justice with a blindfold on, because anyone who comes before the law should be viewed based upon what they did, not who they are. And if you do not have the ability to confront your accuser, you don't have the ability to defend yourself. And that leads to people who want to hurt others to have a weapon to do it. And that's a bad thing.
All right. Well, thank you very much for coming on, sir.
Thank you for having me. You've been a delight.
I appreciate that. Bob Farley in the studio with us. Of course, Uncle Bob to Justin.
As always.
As always. Thank you for tuning in. We'll be back next week talking about the 7th Amendment. Summer of Rights, keeping it going. We're halfway done already, dude. We're over halfway done. All right. Don't forget to like and subscribe on YouTube. Don't forget to leave us a comment. Write to us. Email us. Hit us up on WVCR website. Follow us on Instagram at callingoutcontroversy. Email us callingoutcontroversy@gmail.com. Tell us what you think. Send us questions, please. We love answering questions. We love hearing from our listeners. We appreciate our listeners. And this